It is winter in Massachusetts, in a coastal town called Duxbury, and a woman is lying in a hospital bed in Boston that she cannot get out of. A laptop has been set up on a table beside her. Through the screen, a court is arraigning her on 3 counts of murder. Her name is Lindsay Clancy. She is a labor and delivery nurse. The 3 children who died on the 24th of January 2023 were her own. Cora was 5. Dawson was 3. Callan was 8 months old. She has never denied that she killed them. That is not what her trial is about. The trial that began in Plymouth Superior Court in July 2026 is about one question, and it is a question the American legal system has been arguing over for 200 years. Was she criminally responsible for what she did, or was she so ill that the law does not hold her accountable? As of the 26th of August 2026, the jury has not answered it. Closing arguments have not yet been delivered. No verdict exists. This is what the evidence in that courtroom actually showed. Lindsay Clancy grew up in Massachusetts and became a labor and delivery nurse at Massachusetts General Hospital, which is one of the most demanding hospitals in the country to do that job. She spent her working life helping other women through childbirth. Colleagues described her as capable and careful. She married Patrick Clancy, and they had 3 children over 5 years. Cora was born in 2017, Dawson in 2018. Their 3rd child, Callan, was born in May 2022. By every account entered into evidence, the first 2 pregnancies were unremarkable. There was no psychiatric history of any significance, no previous hospitalization, nothing in the record that anyone would have flagged. The family lived on Summer Street in Duxbury, a quiet coastal town about 40 minutes south of Boston. Patrick worked in technology. They had a basement, a yard, 3 small children, and an ordinary life. Then, in the autumn of 2022, something began to go wrong. It started with returning to work. Testimony described a woman becoming increasingly anxious about leaving her infant son, then increasingly unable to sleep, then unable to describe what was happening to her in words that made sense to the people around her. In October 2022, she was prescribed Zoloft, a common antidepressant. What happened next is one of the central disputes of the trial. 2 of her own providers testified that she had an unusual reaction to it. One described her being awake for 48 consecutive hours. A nurse practitioner testified that this pattern can indicate an underlying bipolar disorder rather than depression. What followed was 4 months of adjustments. Testimony at trial indicated she was prescribed roughly 13 different psychiatric medications across that period, by more than one provider, in more than one health system. Antidepressants, antipsychotics, sedatives, mood stabilizers. Her defense calls this polypharmacy. Their argument is that a woman who arrived asking for help was moved between clinicians who did not adequately coordinate and was medicated in combinations that made her worse rather than better. By late November, she was requesting medication changes almost daily. She was reporting insomnia. She was reporting intrusive thoughts. On the 20th of December 2022, she was evaluated at a specialist center for women's behavioral health in Providence, Rhode Island. According to trial testimony, she was told she did not have postpartum depression. 9 days later, her condition had deteriorated to the point that she was reporting thoughts of harming herself and thoughts of harming her children. On the 1st of January 2023, Lindsay Clancy admitted herself to McLean Hospital in Belmont, one of the most respected psychiatric hospitals in the United States. She went voluntarily. She asked to be there. She was discharged 5 days later, on the 5th of January. Testimony indicated she was not flagged on discharge as a danger to herself or to others. She went home, returned to her outpatient psychiatrist, and her medications were adjusted again. And then, for about 2 weeks, she appeared to get better. On the 7th of January, she hosted a birthday party for Cora, who was turning 5. There are photographs. The family went to a museum. They took a trip to a water park on Cape Cod. Patrick Clancy testified that during this period he had no cause for serious concern. On the 23rd of January, Lindsay wrote a note on her phone. In it, she described what she was experiencing as a touch of postpartum anxiety. The following evening, she asked Patrick to go out and pick up food and medication. What happened in that house on the 24th of January 2023 is not in dispute and does not need to be described here. Cora and Dawson died that night. Callan died 3 days later in hospital. Lindsay Clancy then attempted to take her own life. She survived, with injuries that left her paralyzed from the sternum down. She has used a wheelchair ever since. She was arrested. She was arraigned from a hospital bed through a screen because she could not be transported to a courtroom. A grand jury indicted her later that year on 3 counts of murder and 3 counts of strangulation. She entered a plea of not guilty by reason of lack of criminal responsibility. For 3 years she has been held in state custody at Duxbury Hospital while the case worked its way toward trial. Now, the legal question, because everything else depends on it. Massachusetts does not use the insanity standard most people know from television. It follows a 1967 decision called Commonwealth versus McHowell, which sets a 2-part test. A defendant is not criminally responsible if, because of a mental disease or defect, they lacked substantial capacity either to appreciate that what they were doing was wrong or to conform their conduct to the law. Either branch is enough. She does not have to satisfy both. And there is a second feature of Massachusetts law that matters enormously here. Once the defense puts criminal responsibility in play with credible evidence, the burden shifts. The prosecution must prove beyond a reasonable doubt that she was criminally responsible. The defense does not have to prove that she was insane. There is one more thing worth understanding, because it is routinely misreported. A verdict of not criminally responsible is not a release. Under Massachusetts law, she would be committed to a state psychiatric facility for evaluation, and then potentially for 6 months, renewable in 1-year increments, for as long as she remains mentally ill and dangerous. In practice, that can mean the rest of her life. The defense case was built on 3 kinds of witness. The first were the people who treated her, providers, family members, and her mother, who testified that she watched her daughter's mind come apart over a period of months. The second was a hospital chaplain named Sheila Kavanaugh, who met Lindsay Clancy after the killings and, by her own testimony, has met with her roughly 200 times since. Kavanaugh testified that Clancy told her a voice had commanded her, and that if she did not obey it, neither she nor the children would be safe. She also testified that on the 31st of January 2023, Clancy told her she was glad her children were safe. That testimony was challenged hard. On cross-examination, a prosecutor pointed out that Kavanaugh kept detailed notes and that those notes never once recorded Clancy mentioning a voice. Kavanaugh replied that she was not there to evaluate a patient. She was there, she said, to bear witness to their suffering. The third category was the experts. Dr. Paul Zeisel, a forensic psychologist who has met with Clancy roughly 60 times since February 2023, testified that she was psychotic and could not appreciate the wrongfulness of her actions. The defense closed with Dr. Phillip Resnick, who is one of the most cited forensic psychiatrists in the country on this exact subject. He testified for the defense at the retrial of Andrea Yates in Texas in 2006. He has consulted on some of the most examined criminal cases of the last 40 years. Resnick testified that Clancy was frankly psychotic on the day of the killings. He described a command hallucination and what he called a delusion of influence, a sensation that an external force had taken control of her body. He characterized what happened as altruistic filicide, a term used in his field for a parent who kills out of a delusional belief that they are protecting the child rather than out of anger. He also testified that a standard psychological test administered on behalf of the prosecution, showed that Clancy was minimizing her symptoms rather than exaggerating them. The prosecution has never argued that Lindsay Clancy was well. Their argument, put to the jury in opening statements, is that she was seriously depressed but not psychotic, and that she acted intentionally, rationally, and swiftly. The evidence they built that on is largely documentary. A state police analyst testified about internet searches on family devices going back to August 2022. Prosecutors say she used a mapping application to estimate how long Patrick would be gone. They say she sent him to a restaurant farther from home than usual and added a pharmacy stop. They also point to what she said immediately afterward. In the minutes after the children died, prosecutors say, she told her husband that she had tried to kill herself. She did not say she had heard a voice. According to the prosecution, she reported the command hallucination only later. Their rebuttal experts came in 3 waves. Dr. Avram Mack testified that she was suffering a major depressive episode rather than psychosis. Dr. Kirk Heilbrun, a forensic psychologist who interviewed her for about 10 hours across 3 days in April 2026, testified that she was criminally responsible and called the reported command hallucination very unusual precisely because she described it as occurring only during the killings themselves. Heilbrun's testimony produced the most serious legal fight of the trial. On the 24th of August, he referenced Clancy's Catholic faith and the concept of mortal sin. The defense moved immediately for a mistrial. Judge William Sullivan called the testimony absolutely inappropriate and struck it from the record, instructing jurors to disregard it, but he denied the motion. If there is a conviction, expect that exchange to appear in the appeal. Under cross-examination, Heilbrun acknowledged he had been paid roughly $54,000 and that his recent experience with postpartum psychosis specifically was limited. The prosecution's final rebuttal witness, on the 25th of August, was Dr. Gregory Saathoff, a senior psychiatrist with the Behavioral Analysis Unit at the Federal Bureau of Investigation. He testified that Clancy understood the wrongfulness of what she was doing and was capable of conforming her conduct to the law, notwithstanding her illness, which is where the case stands as this is published. The prosecution was expected to rest on the 26th of August. Closing arguments and jury instructions are expected on the 27th, with deliberations likely beginning after that. The jury is made up of 12 women and 6 men, and the verdict must be unanimous. At a hearing on the 20th of August, the judge and the attorneys argued over what options that jury will actually be given. The Commonwealth is pursuing first-degree murder. The defense has pushed for involuntary manslaughter to appear on the verdict slip as well, which prosecutors oppose. That argument matters more than it sounds, because it determines whether a compromise verdict is even available. If she is convicted of first-degree murder in Massachusetts, the sentence is automatic: life in prison without the possibility of parole. If the jury finds she was not criminally responsible, she goes to a locked psychiatric facility, and the question of whether she ever leaves it is revisited by a court for the rest of her life. There is a comparison that has followed this case from the first day, and it is worth being accurate about it. In 2001, a Texas mother named Andrea Yates drowned her 5 children during what was later widely accepted to be a severe psychotic episode. She was convicted at her first trial. That conviction was overturned, and at her retrial in 2006, a jury found her not guilty by reason of insanity. She was sent to a state hospital, where she has remained ever since, and has repeatedly declined to seek release. That is what an insanity verdict actually looks like in practice, and it is why the framing of these cases as somebody getting away with something tends to collapse on contact with the facts. Postpartum psychosis is rare. Medical literature places it at roughly 1 to 2 cases in every 1,000 births, and it is treated as a psychiatric emergency because of how fast it moves and how high the associated risks are. Postpartum depression, which is a different and far more common condition, affects roughly 1 in 7 or 1 in 8 women after childbirth in the United States. There is a complication in Clancy's case that prosecutors pressed repeatedly. Postpartum psychosis typically has a rapid onset, within days or weeks of childbirth. Callan was 8 months old. The case has already changed policy in Massachusetts. A 2024 state law expanded requirements around postpartum mental health screening and created a state helpline. Advocates are pushing a further bill that would require mental health evaluation for new mothers charged with crimes. And there is Patrick Clancy, who lost all 3 of his children in a single night, and who has been at the center of this in a way almost no one is asked to be. Within days, he asked the public to forgive his wife. He wrote that the real Lindsay was generously loving toward everyone. In an interview 2 years later, he said that he had not been married to a monster. He had been married to someone who got sick. He has since divorced, remarried, and moved away. He testified for the prosecution as its first witness. He has also helped establish a foundation in his children's memory focused on perinatal mental health, and he has filed suit against the medical providers who treated his former wife in the months before she killed their children. The jury will decide what the law says about Lindsay Clancy. It cannot decide the other question, which is how a trained nurse inside one of the best hospital systems in the world asked for psychiatric help repeatedly, was admitted, was discharged after 5 days, and ended up where she ended up. That question is not going to be answered on a verdict slip. If you are struggling after childbirth, or you are worried about someone who is, Postpartum Support International operates a helpline for exactly this. And in the United States, the 988 Suicide and Crisis Lifeline is available at any hour. Postpartum psychosis is a medical emergency, and it is treatable when it is caught. Uncertain verdict status. This is the single most important item. As of the 26th of August 2026, no verdict had been returned and closing arguments had not occurred. Confirm the current position before publishing. If a verdict has landed, the final third of this script must be rewritten. The medication count. Roughly 13 medications across 4 months is drawn from trial testimony as reported, but the exact list, doses, and prescribers were contested at trial. I have deliberately not named individual drugs beyond Zoloft, which was directly the subject of provider testimony. The characterization of internet searches. The prosecution frames these as evidence of planning. The defense frames them as searches relating to suicide. The script presents the existence of the searches without adopting either interpretation. Whether Clancy was formally told, she did not have postpartum depression at the December 2022 evaluation. Reported in trial coverage, and the precise clinical wording used is not clear from the record I could verify. The 48 hours awake detail. Reported through provider testimony as relayed by outlets, not from a transcript. Heilbrun's fee. Reported as approximately $54,000 based on his own estimate under cross-examination. The exact composition of the jury. Reported as 12 women and 6 men including alternates. Confirmed before stating on camera. Method detail has been deliberately omitted throughout, for both monetization and responsible reporting reasons. Do not add it back in. The postpartum depression prevalence figure varies by source and by state, from roughly 1 in 8 nationally to 1 in 7 in Massachusetts specifically. Both are cited here loosely rather than precisely.